Good afternoon, and thank you everybody for joining us today for this webinar on the eviction of residential tenants under a writ of possession and how to instruct the High Court Enforcement Officer. As you're aware, today's webinar is CPD accredited and you should receive your certificate via email 24 hours after this broadcast is finished. Thank you for everybody tuning in today. We have had close to 250 participants. Quick technical tour of the software we're going to be using today. You'll see on the right hand side there is a dashboard. This can be minimized or maximized by clicking the white arrow in the orange box, and questions can be asked throughout the webinar, which we will try to address at the end. If everybody can hear us okay, if you can just type yes into the box. Good, it looks like the sound quality is okay. If we do encounter any technical issues or any sound interferences, please do let us know throughout and we'll try and rectify it as we go along. So before we go any further, a quick disclaimer. Please treat the contents of this webinar as food for thought only. Don't take any action based on its content unless you've taken any independent legal advice. The speakers cannot accept responsibility for any errors, inaccuracies, loss or damage unless we've given you personally specific advice relating to a matter about which you've given us the full background details for. You should also bear in mind that the contents of the webinar are based on current English law, and because of such, and because it contains archival material, at some point this material is bound to go out of date. So let me introduce you to today's speakers. I'll start by introducing myself. My name's Sam Evans. I am one of the 3 business development managers that's going to be speaking throughout today's webinar. I have 7 years experience within the enforcement industry. My job within the group is I have the responsibility for maintaining current relationships with existing clients and obtaining new business. I currently hold the Level 3 award in taking control of goods, and I am on the educational pathway to becoming a High Court Enforcement Officer. I'm also a certificated enforcement agent, and I have a strong focus on delivering an education to the enforcement sector. Our second speaker today is going to be Mr. Jason Wynne-Williams.
Hello, everybody.
Who is suffering from a bit of man flu, so might not be full of exuberance today, but bear with him. As I say, Jason's one of the business development managers, again with over 7 years experience within the group. He too is a certificated enforcement agent, but over and above that, he holds the Level 3 award in taking control of goods and is also on the educational pathway towards authorization. Jason's aim is to provide an education to new and existing clients to help them gain an understanding of the enforcement industry. That's Jason. And then the final speaker today will be Mr. Scott Shimker. Good afternoon. Scott, again, is a business development manager within our group. He covers the east of the UK. Scott has been with us since 2013. Prior to his involvement with the client services team, he was the head of our transfers department. He was there responsible for all matters transferred into a High Court writ of control or writ of possession. Therefore, he's our specialist in court procedures and documentation, and he holds the Level 2 award in taking control of goods. Scott believes in strong client relationships and an education in order to maximise potential recoveries, don't you, Scott?
Certainly do.
So before we go any further and we enter the main the bulk of the content today, I want to start with a quick poll. So you'll see this pop up onto your screen now. So firstly, do you own property? Give you a couple of seconds to just populate this. We're asking this because we know there's kind of a mixed audience signed up today, so just so we can get a feel of who is listening. So far, it's shown that over 2/3 of all people registered do currently own property. Okay, so we'll close that poll down now. Thank you very much. So the second question you should see appear on the screen. Have you ever had to evict a tenant previously? Now, for any of the solicitors who have signed up today, if you want to answer this on behalf of your clients, again, just so we can get an understanding of the kind of people we have in the room today. Surprisingly so, it's actually quite a large percentage of people answering the poll who have had to evict a tenant. Currently looking around 70%. Give you a couple more seconds just to populate that. Okay, so yeah, that's around 68% of you have had to evict a tenant. So for those who did you instruct via the county court bailiff, or did you evict a tenant using a High Court Enforcement Officer? Again, probably expecting this one to be a bit of a mixed result. Yeah, so far currently showing around 75% of those who've had to evict a tenant use the county court bailiff. But again, we'll give you a couple more seconds just to populate this before we close it down. Okay, so yeah, the results have remained the same. Around 75% of those who have had to evict a tenant use the county court bailiff, which the contents of today's webinar might show how the benefits of using a High Court enforcement officer might assist you. So before we go on then, just covering what we were going to go over today. Firstly, we're going to speak about High Court Enforcement Group, who we are, and a bit about our background. We're going to discuss the ideal scenario surrounding property rental. We will look at the landlord's dilemma, which might appear a bit vague at first instance, but Jason will talk over that and what that means later on. We'll look at a fee overview when instructing the county court bailiff versus instructing a High Court enforcement officer, and what are the costs associated. We will look at Section 42 of the County Courts Act 1984. This is going to prove to be an important part of today. If you do leave with anything today, please remember this act. We'll look at the transfer process, and then finally, we'll look at the eviction. So at this stage now, I'm going to hand you over to Mr. Jason Wynne-Williams, and he'll tell you a bit about who we are.
Right, thank you very much, Sam. As Sam mentioned earlier, I am suffering from quite a severe case of man flu at the moment. So for any ladies tuned in today, if you just like to Google that, it is scientifically proven. So bear with me if my voice does go, or if I sound a bit stuffily at any stage. So about High Court Enforcement Group. So as a company, we were formed back in 2004 when various companies kind of joined forces when the rules and regulations in the industry changed to form one group of companies. So at present, we're the largest privately owned enforcement company across England and Wales, and we consist of kind of three separate companies. We've got High Court Enforcement, who deal with the enforcement of writs of control and writs of possession to reclaim money and land. We've got XL Civil Enforcement. Now they tend to deal with things such as council tax arrears, parking fines, sundry debts, and they deal a lot with local authorities across the country. And then we've got the National Eviction Team, who specialise in a lot of traveller evictions, many protester cases such as protesters on runways, Manchester Airport, Gatwick, traveller sites, things like that, all across the country. So last calendar year, in 2017, the group enforced just shy of 24,000 writs across England and Wales. All of our staff, they're pay-as-you-earn employed. That helps us with exemplary compliance, control and development. In our team, we've got 17 authorised High Court enforcement officers, but also within the team, we've got the Vice Chairman of the High Court Enforcement Officers Association, and we also have the current Chairman of the Civil Courts Users Association. So we've got friends in many high places, and we get to learn about many ongoings in the industry before anybody else. Over the years then, our group, we've become synonymous for our unparalleled professional integrity, our ethical approach. Obviously, we've got a duty of care for the debtors as well as you as the client, and our ability to deliver effective, proactive debt recovery. So we'll move on to the ideal scenario. Now, there's a bit of a romantic belief surrounding landlords and tenancy. So the idea being, you as the landlord, you've done your research, you think you found yourself the perfect tenant, so you'll hand the keys over to them, then all of a sudden you've got all this cash flowing in, more money than you know what to do with. But as we all know, not everybody lives happily ever after. People's circumstances often change, and that results in the need for enforcement, and that's where we come into it. I mean, if there was this ideal scenario, I'm pretty sure we'd all be out of a job and looking elsewhere. We can back this up. We've got a case study here, but it's a bit different to your usual case study. This one dates back to 1890, and it's actually a song by an artist called Frank Harding. Now, his song is called Murphy Owes Me Rent, And basically it's a song about a well-respected landlord. The landlord owns several properties across the country, but in just one of those properties he's got a tenant named Murphy, and Murphy hasn't paid any rent for many a day. Now the song goes on to explain about Murphy's free ride. It tells us about the damage that Murphy insists on causing before he leaves the property and the troubles that he causes the landlord. Now the statistics, they more than back this up. So the Ministry of Justice released these statistics in Q2 this year. This is just in one quarter, bearing in mind. Just shy of 30,000 possession claims were started at the local county court. Of those 30,000, just shy of 23,000 resulted in orders for possession granted by a judge. Then again, 14,000 of those orders resulted in warrants for possession. Now, a warrant for possession is effectively the piece of paper that gives the county court bailiff their powers. And of those 14,000 warrants, just over 8,000 resulted in repossessions by a county court bailiff. Now, you may be wondering, 30,000 claims were initiated at court, but only 8,000 evictions were carried out by the county court bailiff. Why is there such a drop? It could be for any number of reasons, really. It could be that the landlord or the solicitor has completely lost the will to live with the court process. It could be the delays that are being encountered. The landlord may effectively write off the rent arrears and just ask the tenant to leave. Or it may be that the landlord's gone down alternative routes, such as ourselves in the High Court. So our caseload isn't incorporated into those 8,000 repossessions by the county court. The song that we spoke about previously then, it concludes by saying, a sheriff I'll send to him to collar every cent, and I will march him off to prison if he doesn't pay the rent. So looking at a national problem, really, these statistics are all released. They're the most up-to-date statistics by Home Let Rental Index. And as you can see, all across England and Wales, the majority of areas, the rent prices have gone up. You can see in areas such as London, these have gone up quite significantly. So for you as the landlord, or acting on behalf of the landlord, it's kind of time is of the essence. Any delays or problems that you encounter, it's just further loss for you personally or for your clients. And as you can see, some areas of the country are worse than others. And I'm sure some of you would have experienced rises in these prices and further problems if you've encountered problem tenants. So as a landlord, you've got a slight dilemma. Your landlord rent prices, they're increasing year in, year out. The tenants are getting no better. Like I said, people's circumstances always change. So at some point down the line, you're probably likely to need to evict somebody from a property. The dilemma comes when you start your claim at court. So you see some of the timescales here. Again, these are from the Ministry of Justice, Q2 of 2018. So it shows that the time from making your initial claim to court until the time the judge actually gives you your court order is a 12-week period. Over and above that, the time from you making your initial claim to getting the warrant of possession that gives the county court bailiffs their powers is 38 weeks. And then again, the time from you making your initial claim to the time that the county court bailiff is on the doorstep evicting a tenant is a 42-week period. So if we take those statistics from the previous slide with the average UK rent price, we've calculated that to be £928 per month. If you multiply that by the average time it takes the county court bailiff to repossess at 42 weeks, we're looking at a figure of close to £10,000. Now this figure is just lost rent. This doesn't incorporate your court fees, your legal fees, any damage caused to the property. This is just a figure for lost rent. So if you calculate the time at the top, 12 weeks for you to obtain your court order, and then the time to attend the doorstep by the county court bailiff, you're looking at a 30-week waiting period whilst you've got that court order in your possession. So what's the alternative Well, that's where we come into it as High Court enforcement officers. We can often operate much more efficiently than the county court due to our resource. We're all authorised by the Lord Chancellor. We've previously been known as sheriffs. So back in 2004, before the regulations changed, there were 173 sheriffs across the country. However, today, there's only 43 High Court enforcement officers across England and Wales. Of those 43 officers, HCE Group, we have 17 of those, as I mentioned earlier on. And all of our High Court enforcement officers, they're authorised to enforce writs of control if you need to recover money owed at £600 and above. And they can also enforce writs of possession to reclaim land and property. So effectively, we're a hypothetical insurance policy. Although you don't pay us any premiums, we're just kind of there as peace of mind should it all go wrong. So our transfer goal, we've looked at the county court timescales earlier on. So we're going to elaborate on each of these parts of the flowchart in our later slides, but just to give you some idea as to the difference in timescales. You as the landlord, you'll need to obtain the possession order, including permission to transfer using section 42 of the County Courts Act, which we'll explain later. So that's your initial 12-week period there that we touched on earlier. There's not really any avoiding that. You need to go through that period to get the court documents that we need. But from that point, if you to instruct us today, we'd complete all the relevant documentation and advise the tenant of our intentions. That's going to take us a couple of days to send back and forth between yourself and us, and we also need your signature on the bottom of the documents. We'll then send all those forms off to court. Now the court take between 24 and 48 hours. We've tied that down in London quite nicely, and we've got a good process in place. And once we get those forms back, we'll issue the tenant with a notice of eviction, which gives them 7 days notice. It also gives them a date and time of eviction, just to make them and everyone else aware of what our intentions are. So from the point you instruct us today, depending where that falls on weekends and bank holidays, in approximately 10 to 14 days, we're going to be on the doorstep. We're going to be evicting the tenant, changing the locks and signing the property back over to the landlord or their representative. So when you take that into account, 10 to 14 days, bear in mind you've already had to wait 12 weeks for the court order, but that 10 to 14 days is a lot quicker than that 30-week turnaround for the county court bailiff that the Ministry of Justice have released the statistics on. So it's just food for thought with, loss of rent, things like that. As for the costs, obviously with an expedited service, you would expect to pay a little bit more money. So if we break down the costs, we've got the county court bailiff on the left and the High Court enforcement officer on the right hand side. So the cost of the initial claim, like I said, there's no avoiding this. This is the fee that is incurred that initial 12-week period for you to obtain the court documents. Now, depending which route you choose to go down, again, we'll elaborate on these later. There's the standard route or the accelerated route. That's going to cost you a maximum of £355. The differences then come into it with the actual paperwork that gives us our powers. So the warrant of possession from the county court, there's a fee of £121 to get the warrant of possession, which gives the bailiffs their powers. The High Court equivalent is a High Court writ of possession, and that is a combined cost of £100 application fee and a £66 fee for the court to stamp the writ. So there's £166 there, which is slightly more than the county court equivalent. When you then factor in your High Court enforcement officer's costs, now our current fee for a residential property is £375 plus VAT. This may differ depending on your choice of supplier. I know there's maybe 4 or 5 main companies out there that offer this service, so please do just check with them before you instruct. But then the main difference is when you factor in the delays. We spoke earlier about the 10 to 14 day turnaround for the High Court enforcement officer, so we're trying to keep loss of rent to a minimum. Then when you look at the county court, depending which area of the country you're at, again, you could be looking at loss of rent anywhere in the region of 12-week wait. We've taken as an example at £2,700 in lost rent. So So the actual total for the county court bailiff, it's kind of who knows. It depends on areas of the country, it depends on the county court's resources at that given time. I know certainly coming up to the Christmas period next month, they're going to be incredibly stretched for resource with holidays, courts closing down, whereas we're a private company, our resources stretch across the country and we don't seem to experience the same delays. So you've got a better ballpark figure there, £941 to instruct the High Court enforcement officer. That's not going to differ too much depending on who your provider is. So at least you've got some kind of figure in mind. Now I've put at the bottom there, depending on the requirement of an N244 application, there may be a further £255 fee payable. Now in our later slides, we're going to explain how you can avoid that and include everything within your initial application. So that £300 fee at the top. If you forget, or if the judge doesn't grant you permission at the time of your initial application, you can always go back to court and make a further application, but that's when that extra £255 fee is payable. So at this point, I'm going to hand you back over to Sam. He's going to conduct a few questions with you guys just to make sure that nobody's fallen asleep. So Sam, I'll pass you back over.
Thanks for that, Jason. I'm sure the information that we've covered up to this point so far has been an eye-opener for many of the people in the room so far. Obviously, longer waits than many will be aware of, and obviously increased financial loss to the landlord. So the first question we're going to cover then as part of our learning review. On average, how long does it take from starting a claim to having a possession order enforced in the county court? You'll see you've got a couple of options on your screen there. A couple of seconds for everybody to answer those and see if Jason has in fact sent anybody to sleep. Just a few more seconds, but it looks like the majority are getting this one correct. Okay, so if we close that down, yep, 62% of the people who answered that question got that correct. It is in fact a 42-week wait. So if we move on to our next question. From the point of obtaining the correct court documentation, how quickly could a High Court enforcement officer enforce an order for possession? So a couple of answers on the screen there. You've got 10 to 14 days, 12 weeks, or 42 weeks. Again, a lot of people getting this one correct.
Shows they've been listening.
It does. Okay, a couple more seconds, let that run, and then we'll close this one down. So yet 92% of the people who answered that question got that one correct. We can act on average and have the tenant out of the property from the point of instruction 10 to 14 days later on. And then the final question in this learning review, how much is the court fee to obtain a High Court writ of possession? And again, three options. You've got £100, £121 and £166. Seems to be a more varied approach to this one. Okay, last few seconds. Okay, so almost 60% of the people have got this one correct. It's £166 for us to obtain the correct documentation to get the writ of possession. Those who have answered £121, please remember that was the fee for the warrant of possession in the county court. So that kind of draws a close to our first of two learning reviews. And at this point, I'm going to hand you over to Scott Shimker, and he is going to tell you about the pre-writ client requirements before you can instruct us. Scott.
Thanks, Sam, and well done to Jason on battling through. So, as Sam alluded to earlier, there are numerous different types of client that instruct us, including firms of solicitors, letting agents, private landlords, and insurance companies. Despite the difference in clients, the process is always the same, and that starts with you serving notice on your tenant, either Section 8 or Section 21. Once you've served that notice, you then need to obtain an order for possession, and also, if you wish to instruct the High Court enforcement officer, you will need the permission of the court, which is granted under Section 2 of the County Courts Act 1984. In order to obtain the possession order, you can either go online on possessionclaims.gov.uk, or you can submit claim form M5 or M5B to your local county court. There is a fee payable, and you can either pay £325 for the standard procedure or £355 for the accelerated procedure. It is worth noting that if you use the accelerated procedure, you won't be able to claim rent arrears. So what you can see on the screen now is the process of obtaining that permission to transfer to the High Court. And you can see that firstly, you'll obtain your order for possession. In that claim, you need to request permission to transfer to the High Court, and it will be at the judge's discretion whether that is granted or not. If it is granted, then you can instruct the HCEO straight away, and if not, you will need to make a further application to the court using form N244, and that will cost £255. So in order to save time and money, it is worth including it in your initial claim.
I think that answers one of the questions we've had in from Mohammed. At which stage do you have to request transfer to the High Court? So I hope this flowchart explains it in a bit more detail. You can request the permission from the outset when you're making your initial application for your order, yeah?
Get it in there first. So when you make the application, obviously you'll need to give reasons, because this application will go before a judge, and they will want to be satisfied that it will be beneficial for you to transfer to the High Court and have a HCEO commence with the eviction. Some of the reasons that you could include in the application include delays with the county court in terms of the processes and processing paperwork, and also delays with the county court bailiff. Obviously, while them delays are going on, you're facing further financial difficulty because you've got no rental income, and there is a possibility of increased risk of damage to the property.
And we've had a question come in from Matt Jones. Now, Matt asks, why would a judge not give permission to transfer? If you want to take that one, Jason?
Yeah, I mean, it could be for any number of reasons. If the judge isn't satisfied with the reasons contained within your application, if you've not elaborated enough and explained why you feel you need to expedite the process, then they won't give permission. They may be aware that in a certain region, let's just choose one off the top of my head, Newcastle, the county court may not be stretched at the moment. They may be able to complete the eviction in 2 weeks' time. So one of the common historic problems that the judges thought was that the cost of the eviction in the High Court would then burden the tenant even further. But I think they're becoming wise to the fact that that's not the case these days. It's actually the landlord or the instructing client that pays the fee. We would never burden the tenant with the cost of an eviction, because at the end of the day, they're not paying their rent in the first place. What's the likelihood of us recovering our fees? It's probably very slim. So I hope that answers that one for you, Matt.
Okay. And also, if you do choose to go down this route and use the HCEO, we will be able to action the instruction quicker than the county court bailiff, whether they have delays or not. If you are going to include that in the application, it is worth checking with the county court before you submit it, because obviously if that goes before a judge, it's quite easy for them to check. And also, something that the judge will like if you include will be the fact that we will give 7 days notice to the tenant prior to evicting them. The wording that you can see at the bottom of the screen in orange is the wording that you would need to use in the application, and obviously just pick and choose the reasons as to why you wish to transfer.
I think that answers a few questions. We've had a few flying in on this slide, as things such as, is there a box that can be ticked on the form to request permission? How does the landlord ask for permission? So there's a few questions coming in. So the orange text you can see at the bottom, we'll make copies of all the slides available in 24 hours. I mean, this is wording that we've had experience with. We've never had any issues with it. So if you're happy to copy and paste, it's entirely up to yourselves. We're not going to say it's guaranteed to satisfy the judge, because it is at the judge's discretion. But we'll happily provide that wording for anybody that asks.
It's important to note as well that whilst it is at the judge's discretion, more often than not, we do see that the judge will grant that permission within our group, don't we?
The judge is mostly happy to allow it as long as they've got that 7-day notice.
Yeah.
So in terms of the transfer process, it's relatively simple, despite the fact that it doesn't look like on this slide. So firstly, you'll obtain your order for possession and it'll have that permission included. Secondly, there is another application to be made, which is for permission to issue a writ of possession. That incurs a further court fee of £100. Third is the request for the writ of possession. That's using form PF88 if it's solely writ of possession, and form PF89 if you wish to recover money as well. After that, the court will make a further order in form PF92, and that will give permission to issue the writ of possession or the writ of possession and control. And finally is the writ itself, and the sealing of the writ by the court will incur another court fee of £66. It does look quite complicated on the slide, but the good news for you is that the only one you need to worry about is number 1. Number 2 to 5 is something that we'll do, and it's a completely free service. The only fees that you will pay at this point will be the £100 at point 2 and the 66 at point 5. We'll look after all the paperwork. We'll just need a couple of signatures from you before we submit it to the court.
So when Scott says it's a free service, the 2 fees you see payable there, they're both payable to the courts for the documentation. Our team will complete the forms and paperwork on your behalf. There'll be no additional costs for that. We'll just swallow that into the cost of our service at a later date when we complete the eviction.
Okay, so in terms of recovering rent arrears, it's up to you whether you put them in the initial claim, and it's up to you whether if they're in the initial claim, whether you want us to go out and enforce on them. Things to consider, as you can see on the screen, would be things that would affect the chance of recovery, such as your tenant losing the job, a relationship split and a loss of income, any health problems by anybody at the property, or the possibility of drinks or drugs misuse. I mean, using the accelerated procedure at the point of the initial claim is quicker and cheaper. So if you think that you're unlikely to recover the rent arrears, then it may be worth going down that route. Something else to consider is that if you put them in the initial claim and they're included in the possession order, when we go out and do the eviction, we can do that first, and we can always go back and recover the rent arrears at a later date by tracing the tenants to a new address in a couple of months, if you wanted us to do that.
I think one of the questions that's come in from David, can costs be recovered from the tenants separately using money claim online? The simple answer is yes, but as Scott's just alluded to, you can obtain a writ of possession and control if you want to go after both at the same time. But it's just using a bit of common sense and what is the likelihood of success. If somebody's not been paying their rent, what are the odds on us collecting that amount of money at the same time as giving them the bad news that they're going to be evicted? It's probably highly unlikely unless they've got assets such as a vehicle. So yeah, you can pursue that via many claims online, and then we've got 6 years from that point to enforce that as a writ of control.
I think the question at the bottom sums it up nicely. Is your priority getting the property back ready to rent out again to a new tenant, or is it chasing the money as well?
Okay, so the juicy bit, the eviction. When you instruct us, as I said earlier, we will send you some forms to sign before we submit them to the court. And included in that pack that we send to you will be a questionnaire for you to fill in. And that's purely to help us out when we go out and do the eviction. there'll be some questions about the tenants, questions about the property, and as you can see, we'll commence risk assessments before the eviction. If the tenant's known to the police, we'll take that into consideration. If there's likely to be a breach of the peace, if there's any animals or livestock at the property, or if there's any hazardous materials. And as you can see on the right, we've included a couple of pictures. The top one, you might well think that that's a stable or some kind of outhouse, but it's not. That is actually a house, and the tenant took the window out.
That's the kitchen window. So apologies for anybody that's eating their lunch at the moment, but the tenant was so proud when we attended to evict them that he no longer had to take the hay inside the house to feed them, because the manure had piled up so high inside the house, the horses could actually reach out through the window and eat the hay for themselves. So it just shows some of the sights that we see whilst we're completing the jobs.
It does. I was going to leave the manure bit out, but sorry about Jason. So the second picture, obviously you can see that's the front door of the property. That's barricaded. So not only could we not get in, but the tenant couldn't get out either. So obviously they had another way of getting in and out of the property, which was through a window. We could see footmarks on the windowsill, so that was how we made our way in. And the last picture is just some nice, cute, cuddly dogs that were at the property when we turned up. And obviously, if you're aware before instructing us that there may be animals at the property, then just let us know and we can make the relevant arrangements to deal with that on site. As we said earlier, we do have to send a 7-day notice to the tenants prior to evicting them. And trends do show that a high percentage of tenants leave upon receipt. Depending on what you put in that questionnaire, we will send 2 enforcement agents. It also depends on the size of the property, and all of the agents that go out and attend are equipped with top of the range body cameras should anything go wrong. So there's nothing really for the tenants to come back and, you know, they will have evidence of exactly what happened at the eviction. And once we've completed the eviction, we can either arrange security at the property or a locksmith or both, or you can sort that out yourself. And that's it. I'll hand you back over to Sam for another learning review.
Thanks for that, Scott. Again, I hope everybody listening has found this beneficial so far.
And didn't fall asleep.
Before we conduct the learning review, we've got a few quick fire questions that we can answer just off the cuff. So Tanvir's said, can you seek rent arrears afterwards in separate proceedings? The answer is yes, via money claims online that we touched on earlier. Let's see if we got any other.
I've taken a couple down for later on.
Yeah, one from Rex. Where's the box on the N5B or the N119 form where you can make the section 42 application? So there's no specific area on the form where you can place the word in. You can either attach this to the back or you can enter it within the body of your main notes whilst you're making that application. Is that right, Scott?
Yeah, that's right.
Yeah. Okay. Right. We'll hand back to Sam then for the final learning review before we cover some more general areas of enforcement.
Again, just 3 final questions. So we'll start with, under which section of the County Courts Act 1984 can permission be sought to enforce in the High Court? You'll see you've got 3 options on your screen: Section 41, Section 42, or Section 43. As we said from the outset, this is the big one to remember from today, because this is going to save you both time and money in the long run.
Yeah, this is the main trigger that's going to save you the most over the course of the eviction process.
So if we close that down now, a healthy 96% of listeners have got that one correct. It is, of course, Section 42 of the County Courts Act 1984. So moving on to our next question. If you fail to request permission to transfer to the High Court under Section 42, can you make an application at a later date? And then you've got yes, no, or yes, but only providing the rent arrears exceeds £600. Can give you a couple of seconds to populate the answers. Bit of a curveball in here. So if we close that poll down now, so 65% have answered yes, you can make that secondary application. Obviously C was the curveball. It doesn't matter if the rent arrears exceed £600 in order to move the matter into the High Court. You can complete that under an N244 application. So then you'll be glad to hear the next question is the very last one. Which of the following would prove sufficient to satisfy the judge to grant permission to the High Court? And with this one, it's worth noting that there is more than one correct answer. So you've got the landlord facing financial difficulty, you've got increased risk of damage to property, you've got neighbours do not get on with the tenants, and then finally option D, delays in the county court. A few seconds to answer that one. Okay, so if we close that poll down now, thankfully everybody's got the answers correct. They are A, B and D. Nobody has gone for option C, which would have been incorrect.
And just before we move on from the learning review, a few more quick fire questions that I'll ask Sam these ones. So let's have a look. If the tenant doesn't allow entry, can we force entry?
Yes, we can. As Scott covered, we will attend with a locksmith. So we will always gain entry into that property. Scott did cover off that you can provide your own locksmith. The only thing that we'll ask is that it's from a reputable company. Despite it's charging an initial fee, you know, if we have to wait hours because you chose Dave around the corner who owns a spanner set, you know, there will be further charges. Alternatively, we can provide you with one of the many locksmiths that we use, and we'll just invoice you for that at their cost.
Okay, Scott, can you ask the court to release the deposit to the landlord as well?
Yeah, you can. We actually find that in quite a lot of our possession orders when people instruct us.
It's not something that we offer though, is it? It would have to be done at the time of the initial application.
Yeah, put it in the initial application and the court will put that in your possession order.
Okay, and then Sam, last one. Can you still apply for possession by the High Court if the reasoning for notice is not arrears but other breach? So I'd imagine that's something along the lines of damage, or maybe they're subletting the property illegally.
Yeah, of course. Like we say, what we have to do is we have to satisfy the judge of our reasoning to move it from within the county court to High Court for enforcement. So as many reasons really as you've got. The main ones do seem to be the financial loss to the landlord and the damage caused to the property. Obviously, once the tenant is aware that you're about to evict them, they're not going to leave nicely and pack up. They're probably going to spray paint the walls, damage the kitchen, kick doors through, smash windows. Unfortunately, given the nature of what we do as a business, we do see this relatively often. So yeah, you can include that.
Yeah, and I mean, the order for possession is the main thing. We don't necessarily need to know the background. So, you know, depending which reason you've obtained the order, that's between you and the tenant. Basically, all we're concerned about is you've got that order for possession and that you've got permission to transfer. So it could be for any number of reasons they need to be evicted.
Okay, so if we move on to the next couple of slides then. So how can you help? How can you help? So it's not only how can you help us with enforcement, but it's also how can you help yourself as either the landlord or the solicitor in charge of proceedings. Now at this stage, we don't mean to teach anybody how to suck eggs, but some of the kind of horror stories that we get in to the company, you wouldn't believe the lack of information that the landlord holds. So what we would always encourage is that you gather all that information from the very outset before handing over the keys. Whilst you've got those keys dangling in front of that tenant, they're likely to give you any information that you ask for. So if you obtain things such as contact details, and not just a mobile phone or a landline number, but maybe obtain their email address as well. If you can gather their employment information, their date of birth, and their vehicle registration details, all this kind of information is going to assist should you need to chase those rent arrears and instructing the High Court enforcement officer. Obviously, a vehicle is the best thing that we can recover. when we're attending a property. It's sat on the drive, and it's the first thing one of our enforcement agents will look at. Also establish the tenant's financials, but don't just cite one bank statement. Try and cite as many as possible. You never know when you might need to call on this information for an attachment of earnings. Also ask for a guarantor and obtain all their contact information too. And then further, if you can get a photograph of the tenant via a driver's license or a passport, then this will help us identify the debtor, again, should we need to attend chasing the rent arrears. Moving on, some of the things that are offered by High Court Enforcement Group. So we do offer a free ebook by email. So after this webinar, if you want to attend our website, which is www.hcegroup.co.uk, you will see there is a section on there where you can download a free complimentary ebook. And we do have one on the eviction of residential tenants. Also, like today, we do hold regular free CPD accredited webinars. This is likely to be the last one of 2018, but there will be one early 2019, so keep an eye out for those. And then finally, some of the alternative services that we do offer. We're not just here for residential evictions. I won't read them off all on the screen, you can see them, but again, some of the questions that have come in today: can we chase the rent arrears at a later date? Yes, we can do that under a county court judgment. We can enforce that, tribunal awards. Not only can we evict tenants from residential properties, but we can also evict travellers and complete squatter evictions. We also have commercial forfeitures, vehicle and asset recovery, process serving of legal documents to defenders. And again, if your tenant's gone AWOL and you need them tracing, we do have a tracing facility. We also have links to an international enforcement website. So if your tenant leaves and goes to a European country and you wish to chase them down there, if you get in touch with us, we're happy to supply that information and let you know how you can chase those rent arrears in a European country.
Thanks for not reading those up, Sam.
It's okay, tried. So some of the frequently asked questions that we get into the company, we see a pattern of the same questions coming in time and time again. So we wanted to cover a few of these off today and hope that'll benefit. So I'll read through these and I'll fire these at Scott and Jason, and they'll give you the answer. So one of the questions we get in quite often, Jason: can we use aggression with the tenants?
Okay, so this is slightly different, of course, in entry. I think the reason people ask this is actual physical aggression with the tenants. Now, we can't just barge in and throw somebody out of the property, but we do have authority to use reasonable force. So if they're adamant that they're staying put and they're not leaving the property. Oh, sorry, people are saying that the sound is completely gone.
Microphone.
Hello? Sorry everyone, it looks like we're having some technical difficulties. We'll just check the microphone.
Has the sound returned? Can anybody hear us? If you bear with us a couple of seconds, we are trying to rectify the sound. Has the sound now come back?
Is that better for everybody?
If we can just pop yes in the box just to let us know we're back.
Right, sorry about that, everybody.
Apologies for that. I'm not sure when that cut off, so I'll just go back to the question and ask Jason, can you use aggression with the tenants?
So yeah, as I was saying, slightly different to the question we had with forced entry earlier. I think people ask this in terms of, can we physically remove people from the properties? The answer is yes, we can use reasonable force. If somebody is point blank refusing to leave a property, then it may get to the point where we have to, use an enforcement agent to pick them up by each limb, carry them down the stairs and outside of the property. So yes, if need be, we can. And also, if there's a breach of the peace, we can call in the police to assist, and the police are obliged to assist us with an enforcement, with us being enforcement agents.
Thank you, Jason. So the second question we see, Scott: how do I find out how long the delay is in my local court?
Just give them a ring. give them a ring, ask them, tell them that you want to evict somebody from the property, you want to use the county court bailiff, and they will give you a time scale for an appointment. If you're relatively close, then you can always call in rather than ring them.
Okay then, Jason, I instructed the county court bailiff, but the tenant remains in the property. What is your success rate in evicting a tenant?
Well, our success rate, if you instruct us, is 100%. The trouble sometimes with the county court bailiff, we've mentioned they don't have the same incentives. So if they turn up at a property and somebody's refusing to leave, they may just come back another day, and that obviously adds to the frustration, the delays, the loss of rent. Whereas if you instruct us at High Court enforcement and we've got our writ of possession on the doorstep, then effectively we won't leave that property until the tenant is out and we've changed the locks and signed that property back over. That doesn't matter if it takes us an hour, 3 hours, or a full 8-hour day. You can kind of rest assured that if we're called to action, then we will get that tenant out.
So 100% success rate doesn't really get much better. Finally then, Scott, of the regular questions that we see coming into our office, I have my order for possession. However, this does not include permission to transfer to the High Court. Can you help?
Well, we can help. You do still need the permission. But yeah, give us a call, email in, and we can give you some pointers. If you've already filled the application in, we can have a little look over before you submit it. The only thing we can't do is submit it on your behalf, but yeah, just give us a call or an email.
Okay, so that takes us from the frequently asked questions. We have taken note of some of them as they've come in throughout the course of the past 45 minutes or so. Again, apologies if we haven't covered yours. We will try and cover some off in a newsletter in the coming weeks. So Jason, the first one's coming from Sarah. I have a warrant of possession with the county court bailiff. Can I now instruct you instead?
Yeah, I think a few people, I can see Colette's added this as a question as well in similar terms. So if you've currently got the county court bailiff enforcing on your behalf, you would need evidence that they've returned their case before you can instruct the High Court enforcement officer. What we wouldn't want to turn up on the doorstep and find that the county court bailiff is there already trying to evict the tenant. It's similar to recovering monies. You know, you can't get a warrant of control and a writ of control at the same time, because you can only collect the debt once. You know, we can't evict somebody twice. So yes, you can instruct us, but we need evidence that the county court bailiff is no longer instructed before we can transfer that matter.
Thanks for that, Jason. Scott, we've had a question come in from Adam. Why is it that you were able to act quicker than the county court bailiff? Surely they have the same powers as the High Court enforcement officer.
They do, but I think as Jason said earlier, it's a question of motivation, but it's also a question of resources. The main one being they are severely understaffed. I spoke to a lady a couple of weeks ago who had been given an appointment with the county court bailiff, and they quoted 26 weeks for somebody to go out and evict. So yeah, I think that it's mostly a question of resources.
Okay, thank you. Third question, Jason, from Claire. Is there any other way of securing transfer to the High Court without this section 42, or is there any other act which will allow this?
Right, thanks for this one, Claire. The basic answer is no. If there's a property, whether that be residential or commercial, and there's a tenancy in place, then you do need permission from the court under section 42 of the County Courts Act. Now, slightly off topic now, if you have squatters or travellers in a property of yours and they're trespassing, then you can begin proceedings under trespass, and you can instruct us to complete a writ of possession under trespass, and that does not require the permission. So the easy way to remember it, if there's a tenancy agreement in place, then permission is required.
Thanks, Jason. Scott, we've had one in from Elaine. Elaine asks, I note you said that an N244 application would cost £255. Could we not do this without notice for £100 in order to save our client money?
In short, no. The judge will insist, when it goes before the judge, they'll insist on notice being given. When it comes to evicting people from the properties, the judges at the county court and the high court like for as much notice as possible to be given. So they will always insist on the application with notice, which is 255.
Thanks, Scott. And then I think we'll take this last question before we look to wrap up, which is coming from Thomas. Thomas says, do you have to serve the 7-day eviction notice, or can this be reduced?
So there's nothing in the regulations that say we have to serve the 7-day notice, but as Scott alluded to on the previous question, the judges like to ensure that all parties are kind of aware of the proceedings. They really don't like it if we were to turn up unannounced on somebody's doorstep and turf them out. I think Scott alluded to it possibly on his eviction slide with the horses as well, that often what we find, no matter how many kind of letters and threats and warnings you send to that tenant, until the point where they get our notice of eviction, they don't actually qualify for emergency accommodation from the local authority. Whereas if we issue with them with that notice of eviction, they can take that to their local authority and get emergency accommodation through maybe a housing association or something along those lines. So we're not obliged to send it, but the judge will often not give us the required permission if we don't send that notice. On the occasional one-off case, that 7 days can be reduced to maybe 1 or 2 days. But again, you need to kind of plead your reasons to a judge, and it would be at the judge's discretion whether that permission is granted.
So I think that brings us to the end of today's webinar. Thank you very much to everybody who's tuned in today, for those who have asked questions and those who have participated in our polls. Like we said, there is an ebook available on our website, which you'll find details of which on the screen now. Follow the link, you'll be able to download a free copy of that. Any questions we didn't get to answer will hopefully be fielded in one of our next newsletters. Again, you can sign up for those on our website. But for now, that's us. Thank you very much for tuning in, and have a nice afternoon.
Thank you very much, everybody.
Thank you.